Hello and welcome to TV30, a production of the Government Information Service and NTN. I am your host, Kendall Eugene, and today we have with us the Labour Officer, Mr. Nikolai Lansico. We will be chatting with Mr. Lansico as we get ready to celebrate Labour Day. We will be asking him some of the most frequently asked questions with regards to our Labour Act. Good afternoon, sir. Welcome to TV30.
Afternoon.
Just before we get into it all, let the folks know, what does a Labour officer do? What is your day-to-day?
Well, basically, the role of a Labour officer is to enforce the Act. Similarly, you have police officers who would police the Criminal Act and enforce it. Labour officers similarly police and enforce the Labour Act to ensure that employers are getting what they are supposed to be getting from the employees, and employees are doing their fair bit and getting what they're supposed to get from the employers.
Okay. Normally people would associate anything to do with labor as just work, putting down a normal 9 to 5, 8 to 4:30. You're saying now that it's not just the people who are working it that you're concerned about, you're also concerned about who's providing the employment.
Yes, so most times persons talk about Labour Department, they look at it from the employee's perspective, because persons only come to the Labour Department when they end up in some difficulty with the employer.
Yeah.
So the Labour Department is synonymous with when a worker is in trouble. So you're in trouble, go to the Labour Department, but nobody comes to the Labour Department before to seek advice. But as a Labour officer and coming from the Labour Department, we are in the middle. We are neither for the employer or for the employee. We are here to enforce the provisions of the Act, and of course to be that mediator between the two parties.
Before we get into the Act, because I am sure a lot of people want to know about the Labour Act, what are their rights, what are their wrongs, what they cannot do. Let's talk about something I read about, and it's something that goes along the lines of a probationary period. Now, when I hear probation, I think of somebody who is on a timeline. 3 months, 4 months, 5 months, but a probationary period, how long is that supposed to run?
All right, well, the law speaks to a 12-week period in which an employee ought to be on probation. However, between the employee and the employer, they could agree to have a shorter period or longer period. So, for example, an employer can say your probationary period would be 1 month, 4 weeks, or 6 weeks. Similarly, between the employer and the employee, they can agree to a 6-month probationary period, 180 days.
Yeah.
But once the employee has passed 12 weeks, they begin to accumulate benefits. So they begin to accumulate stuff like vacation and so on. And that is the importance of a probationary period.
Okay.
Once the employee has passed that threshold of 12 weeks, the employee begin to accumulate benefits. So if you were to terminate the employee after 12 weeks, you need a reason for that termination if the employee is outside of the probationary period. But while the employee is on probation, either party can terminate the employment arrangement at any time.
Okay.
So the employee can say, hey, I got something better and I want to leave. During the probationary period, that is fine. The employee can do so without giving any notice to the employer. Similarly, while the employee is on probation, the employer can terminate the employee without notice.
Have you ever gotten a situation where employees would leave a job during that period and say nothing to the employer, not because they found something better, but just out of being malicious? And it's the same for an employer.
All the time. So whether the employees are on probation or not, you will find employees who are mischievous. And for example, an employee would be working for company A and company B offers them a better salary package, better benefits. They would leave, and you would hear the phrase effective immediately. So I am resigning effective immediately, without giving the employer any notice.
Right.
And of course that happens while employees are on probation, as well as when they're off probation. Employees can be working for 10 years and still tell the employer, I want to resign effective immediately. With the employer, during the probationary period, the employer can tell the employee, today's your last day, or tomorrow's your last day while they're on probation. But where it differs with the employer now the employer must give the employee notice once the employee is outside the probationary period.
Okay.
They have to give the employee notice. And of course, once you're outside of the probationary period and you do not give notice in advance, it will be on both sides. You have to pay for the notice in terms of the employer, or the employer can deduct the notice from the employee if they don't give adequate notice.
I get the feeling a lot of our workforce are not aware of just these simple requirements of an employer towards the employee during the probationary period and after. Have you ever gotten a situation where someone came to you and it was evident that they had no idea or they had no clue what their rights were?
All the time. So it is not a one-off event, but it happens all the time. So I see it on a regular basis every day at the office. Persons are not familiar with the act. And in my mind, that ought not to be. If you are working and there is a law that governs what you do as an employee or as an employer, similarly, you ought to familiarize yourself with the act. My advice would be to reach out to the Labor Department, ask to speak to a labor officer, and they would break it down for you. You ask them specific questions, or they would guide you based on your circumstance. And we always say we give you advice based on your circumstance. So you give your circumstance, and we advise you accordingly, whether you're an employee or an employer. And you are right. A lot of persons are unaware of what is in the act and don't know their rights.
I heard a lot of people give their own rights and put their own spin on the act. But we'll come to the act in a little while, because probationary period still has me thinking, can I extend, if I'm an employer, can I extend the probationary period? Or if I'm an employee, can it be extended?
Yes. So the employer can extend the probationary period once the employee agrees.
Okay.
So if the employee says, the employer says to the employee, I'm placing you on a 3-month probation. And at the end of the 3-month period, the employer realizes that the employee is not performing up to standard. The employer can say, hey, we are going to extend your probationary period for an additional 2 months, additional 3 months, 12 weeks, to gauge your performance. So you could pick up. And during that time, the employer can monitor the employee, see if they are making the adjustments that is required in order to give them the job.
Okay, all right. So it's not a position where the employer is going to just let you go, but they're giving you a second chance, per se.
That's correct.
To get, okay, all right. That's understandable, and that's quite commendable on an employer's part,
yes,
if we are to be fair. Now, whenever someone starts working, and in their mind, they have already exceeded the 6-month mark, they start thinking vacation.
That's correct.
They start thinking vacation. Immediately, vacation and raise my pay. I'm no longer on probation. How much vacation is an employee entitled to, and when does it really kick in?
All right, so the vacation begins to accumulate after 12 weeks. So an employee is entitled to vacation every year, and a year is not January calendar, January to December, but it is from the date you start working. So if you start working on the 1st of April, your 1 year anniversary should be March 31st of the following year, and not January to December. So most persons have that mistaken. They figure it is for the year, but it is the year that you start working, and not the calendar year that you are in. Employees who are employed between 1 and 5 years entitled to 14 working days. Employees who've been working over 5 years are entitled to 21 working days. Of course, employers may be lenient, and depending on your job, you can negotiate your vacation time. It can be more than 14 days if you work for less than 5 years, if the employer so agrees to, or more than 21 if the employer so agrees to. But the employer cannot give you less than 14 days.
Okay.
So they can 14 working days. So they can give you more than what is allowed by the law, but not less.
So an individual who's been employed for, let's say, 20 years, would they be entitled to 21 days, or the employer would say, okay, you deserve a month?
That's correct. So 21 days is actually a month, but we'll get to that in a little bit. So the employer can choose to give you 40 days vacation. They can.
Okay.
Once the employer agrees to give you more, they can. The only thing is they cannot give you less.
Yes,
Now, I'm happy that you mentioned 1 month. Vacation is calculated based off of working days, and it does not include Saturdays and Sundays or public holidays. So Monday to Friday. So when you're on vacation, people will say, my employer counts Saturdays because I work on a Saturday as part of my vacation. That is against the law. Your vacation is supposed to be counted from Monday to Friday. So when you do get 21 days vacation, it is actually a month.
A month.
Yes, so it's Monday to Friday, and 4 of that plus 1 day.
All right. So again, I really am happy that you mentioned Saturday and Sunday, because I have heard so many situations where workers are saying my employer has me working on the weekend and he's also counting that during my vacation.
It does happen. It does happen, and I would encourage anybody who is going through something similar to come to the Labor Department and have us rectified for them, because some employers genuinely don't know. And we did mention that just now. Persons are not aware of what obtains in the act.
Right.
And it may be a simple matter of a phone call to get it rectified, and that is that.
Let's talk about the end of a vacation period before we go into our break. When are you legally required to go back to the workplace? Is it the day of the end of your vacation or the day after your vacation has ended?
The day after. So if you have 21 days, on the 22nd day, you go back to work.
So the vacation ends on the 4th of May. I am now due back on the 5th. I'm supposed to be walking in on the 5th, regardless if it is on a Friday.
Yes.
Situation again. Now, sometimes I might think it's me, but it's not really me. 3-4 years on the bounce, I have known one of my colleagues to come back from vacation the day the vacation ended. Does that individual have a right to claim a lost day from that vacation?
They can. And the employer should honor it. They can. And I'm happy that you mentioned the Friday, because people do that all the time. they will take their vacation in such a way where the last day vacation day would be a Thursday, and they figure it's Friday, I'll go to work on Monday instead.
But you can't.
But you can't. You ought to report to work on Friday.
All right. This is a TV30. We're talking here with Mr. Nikolai Lansico. Mr. Lansico is a labor officer at the Labor Relations Unit, and we're getting ready to celebrate Labor Day. Something that I believe a lot of people should be asking a lot about. It is the Labour Act. I don't think that a lot of us actually understand how important that piece of legislation is to us working in the workforce here in St. Lucia and, of course, around the world. When we get back, we will chat with Mr. Lansico on severance and redundancy. And that was a word that I believe gained more popularity during the pandemic, where individuals were made redundant left, right, and center. So when we get back, I want to know the correct term. Which one should I be using? Is it severance or redundancy?
All right.
Okay. We'll take a break, and when we get back, more with Mr. Nikolai Lansico. This is TV30.
Keeping hands clean is important for good health. However, after a disaster, staying clean is hard to do, especially if there is no pipe-borne water. Simple things you can do to stay clean and remain healthy are: wash your hands with soap and clean water. If these are not available, sanitizers with alcohol are options. Wash your hands many times during the day, before preparing food, eating, caring for a sick person or baby, treating a cut, wound, or sore. Wash hands after using the bathroom, changing diapers, caring for animals, caring for sick or injured persons, after handling garbage. Washing your hands is one of the best ways to prevent illness. For further information, contact the Bureau of Health Education at telephone number 468-5349.
Welcome back to TV30. We're chatting here with Mr. Nikolai Lansico, the labor officer at the Labor Relations Unit. Today, of course, we are getting ready to celebrate Labor Day, May Day. Mr. Lansico, you've been giving us quite a lot to think about when we are now at our desks in our workplace. And I know a lot of people will be looking at the employer side eye after we're done here today.
I hope not.
Especially with the vacation part.
I hope not.
But yeah, before we went into the break, I was speaking on this whole severance and redundancy, and we heard redundancy quite a bit during the pandemic. But let's chat about which one is correct to use. Is it what's severance and what's redundancy?
All right. So severance obtained prior to the act being amended. So you'll be working for a certain period of time. Your employer is winding up, closing up shop, is downsizing, restructuring. They would pay you off, which is severance pay, to sever that employment relationship.
Okay.
And they'll pay you off, and then you go about your business. Redundancy is similar in that a redundancy occurs when an employee is either restructuring, downsizing, changing your employment contract. So an employer hires you to work 5 days a week. You used to pay $5,000. He says to you, Mr. Kendall, we are undergoing some financial difficulty. So here's what: you'll work 3 days a week, every other week, and we'll pay you $2,000 a month. So in effect, the employer is making you redundant because they are restructuring the way in which they operate or conduct their business. So that would in effect cause your position to be redundant, and the employer would have to pay you for years of service, as well as notice paid. They don't give you any notice, and whatever outstanding vacation that you may have. What is important is we need to understand the difference between a redundancy and the individual. Individuals are not made redundant. Positions are made redundant. Okay. So you'll hear all the time, my employer made me redundant. My boss made me redundant. But the correct term to use, the correct terminology is they made my position redundant. Okay. Because the company cannot make you as an individual redundant. They can make your position redundant. And I don't think employers have fully understood the whole idea or concept of redundancy insofar as how it relates to the employees and the positions. So what usually obtains is, by the way, severance is no longer in the act. Yeah. Severance is no longer in the act. So the act speaks to redundancy. It doesn't speak to severance. When an employer...
Just before you go into that, so you mean there's no such thing as severance pay anymore?
No. It's redundancy.
Redundancy.
Yes.
Okay.
So severance pay was what you used to obtain prior.
Before.
Yes.
All right.
So when an employer intends to restructure, reorganize, or place people on layoff, it is advisable that they write to the Labor Commissioner informing of the redundancy, not necessarily the individuals, but the positions. So we are not making 12 individuals redundant. We are making 12 positions redundant, and the positions are with clerk. And you come down the line, you list the positions and the reason for the redundancy. Once the Labor Commissioner acknowledges receipt, you go ahead and you do what you have to do. Redundancy is calculated by the amount of years the individual works. So you get a certain amount of weeks based on the years that you work.
Okay. This calculation, is it readily available for anybody to get a hold of and to do their own calculations? Because I believe that is one of the biggest wars that, and I use that word for a reason, because I have seen in various business establishments where individuals irate, livid, walking in because they feel that they had been cheated after they were made redundant with the
calculation. All right, so the calculations are accessible. You could go onto the government website, get a copy of the act. It will give you the breakdown to calculate the redundancy. Similarly, you can call the Labor Department and ask to speak to any labor officer, give them your salary and the amount of years that you've been working, and they will provide you with a final figure.
Do you believe in your professional capacity, or have you ever witnessed where establishments, owners, managers would use the redundancy clause, if you want to call it that, to punish or get rid of employees?
All right, so a while ago we mentioned employees being mischievous, and similarly you have employers who are mischievous, and sometimes you have employers who would say, they simply do not want a particular employee to work there anymore. So they would just find some way, and oftentimes they do it wrongly. They use the redundancy scenario to get rid of an employee, which is wrong. And we always advise against it at the Labor Department, because we do follow up. And if we realize that you made redundant the position of an accounts clerk or in a bakery, a baker, and tomorrow morning you have a sign out, you are hiring a baker, of course we will investigate, and the Labour Commissioner will do the necessaries in order to bring about some penalties for a breach. Because you cannot make a position redundant today and you're hiring for the same position tomorrow. You are making a position redundant because you no longer have need for it in your organization.
Question: if I made, like you said, a baker, made that position redundant, and the next week I have a sign out, baking engineer.
That's interesting.
Is that okay? Can I do that?
You can, because what
I know.
I'm happy you put that spin on it, because you may hire an individual, say for example, a caretaker, and his responsibility is to keep the hedge in check, make sure the grounds are always clean and proper, but his job does not entail him cleaning the glass. If you make that position redundant, and tomorrow you hire a maintenance expert whose job it is to maintain the hedge, similarly keep the grounds clean, clean the glass, and clean the inside of the building, you can't do that. Because you're now changing the function of the position, the operating role of the position.
All right.
And most times the salary would differ.
I would hope so. You mentioned something about notice earlier. What is that? What does notice mean?
All right, so notice is a period of time. And it goes for both the employer and the employee. And we did mention the probationary period. Once an employee has passed the probationary period and the employee wants to leave the job, resign from the job, the employee must give the employer notice. And notice is based on the amount of time that an employee has been working at the establishment. Similarly, if an employer is winding up, is restructuring, is closing down, the employer ought to give the employee notice in advance. And the notice again will be based on how long the employee has worked there and so on. In the absence of the notice period, if an employee fails to give an employer notice, the employer can deduct the notice pay period, whether it's 1 week, 2 weeks, or 3 weeks, whatever is stipulated in the contract, the final pay. So be it vacation benefits or standing wages, the employer can make that deduction from there. Similarly, an employer can say, we are closing up shop next week, but you have an employee who's worked with you for over 10 years. You ought to get an employee 6 weeks notice. The employer in that particular instance has to pay the notice period. So if you don't give the employee adequate notice, you must pay the notice.
Okay. Now, another thing that I believe a lot of employees would be very keen to know, or rather understand a little bit clearer, is how an employer should deal with instances of misconduct. We've seen it happen in many business establishments where, in our eyes, that employee has breached the contract, breached all sorts of disciplinary codes that would probably end their contract, but still nothing is being done.
All right, so the act is specific to misconduct. Section 133 says an employer can dismiss an employee summarily without notice once they follow the proper procedure of Section 140, which is natural justice. So once you've done everything that you had to do in terms of the law, give the employee a natural justice hearing, followed up, do your necessary investigations. Once the employee is found guilty of serious misconduct, now we need to define what serious misconduct is.
Please.
Because serious misconduct, you can say, well, I have a bakery and I ask the employees to wear a hairnet for obvious reasons. You don't want hair falling into the batter, the bread, the cakes, and so on. That may be serious misconduct. But if you are a bus driver, or you work in the transportation industry, wearing a hairnet or not doesn't constitute serious misconduct. So
Correct.
misconduct is specific to the type of industry that you're involved in and the type of work that you do. But there are broad misconduct headings which should cover every aspect, everywhere you work.
Okay.
Things like theft, willful disobedience of a lawful order given by the employer, insubordination, absent without excuse, and these things would transcend every single sector that you come across. Some of them are more specific to different areas, but misconduct must be clearly defined, because you don't want the employer to come down on the employee for every little thing and say, hey, this is misconduct, that is misconduct. It must be clearly defined.
We see that happen quite a bit, where the employer would come down on the employee for what seems like any and everything, and the employee now feels, that they're being targeted. Okay, so you said natural justice, and that for me is very, very important. How does one tell if they have breached the natural justice clause? Is there something in the act that we can find?
So the act is specific in terms of what should obtain coming out or going into a natural justice hearing and coming out of a natural justice hearing. The act says the employee must be given the full particulars of the accusations, because misconduct or alleged misconduct are accusations. Okay. So they until proven guilty. Similar to when you go to criminal court, you are innocent until proven guilty. So the employee in question must be given the full particulars in writing as to what the misconduct is. So you did ABC on X day, and the witnesses are John, Mary, and Paul. The employee must be given notice. So you cannot summon an employee to a disciplinary hearing today for today. You must give them notice, adequate notice. You must also give them the right to representation, legal representation, and to make representation on their behalf. Okay. So these things must obtain as part of the natural justice hearing. If an employer fails to do those things, then they have breached the natural justice provisions of the Act. And that is important. So yes, an employee may be engaging in some act of misconduct, but they must still have a natural justice hearing. Yes, you can see on the camera an employee is going for a bottle of water behind the building, but it could be another manager asking them to bring it behind the building. But you wouldn't know that until you give the employee an opportunity to be heard.
Have that hearing. Yeah. Okay. Now, I know that individuals have often asked, should I be written up before any hearing can be held? What's your say to that?
Yes, the employee must be written to. The law says it must be in writing. The employer must, in writing, inform the employee of the hearing, give them notice of it. So we are going to have a hearing on X date. And these are the particulars, the full particulars of what the allegations against you are.
Okay.
And of course, you have the right to bring a lawyer, to bring somebody to represent you if you so desire.
Mr. Lansiko, thank you so much for joining us this afternoon. We really do appreciate that. But before we let you go, let them know where they can get a copy of the Labours Act and where can they call in case they need help.
All right. So if you go onto the Government of Southern Ontario website, you can download a copy of the Act. It is on there. You just type it in, the Labour Act, it will come up. It's a PDF file, download it, and you could browse through it. Should you have any questions, and not should you have any questions, I would advise that persons call the department and just verify the information that they're reading, because you may interpret the law in one particular way, and that was not the intended or the intentions behind what was written. So it is advisable that yes, you download your own copy, but you always call for advice, and the advice is free.
Ain't nothing better than free. Again, thank you for joining us.
All right.
Ladies and gentlemen, this has been TV30, a production of the Government Information Service and NTN. We're talking the Labours Act. Labor Day is on the way. Just had with us this afternoon Mr. Nikolai Lansiko, Labour Officer. Thanks again for joining us. Have a great day. Bye-bye.